respected Vice Chancellor Sir, and our distinguished guest, Mr. Anil Malhotra. Sir, welcome in our university and for delivering a special lecture on inter-country, that is the child removal and the Indian perspective. Brief profile, sir. Mr. Anil Malhotra is a distinguished advocate based in India with 40 years of experience in Indian family law as RGNUL counsel in courts all over India. He holds Bachelor of Science in 1980 and Bachelor of Laws in 1983 from Punjab University, Chandigarh. And also, Sir did LLM from University of London in 1985. His legal education includes specialized studies in comparative family law at the London School of Economics and Law and Society at the School of Oriental and African Studies. Mr. Malhotra has acted as an expert and amicus curiae in courts over various jurisdictions. He has authored 9 influential books on family law and has contributed significantly to legal literature with significant published work and also 1,500 columns. He is recognized internationally for his contribution to family law and represents India in Family Law Committee of International Law Association, London. His expertise span surrogacy, intercountry adoption, nationality, marriage, divorce, custody, guardianship, and child removal issues, particularly involving global Indians. His reports as amicus curiae on intercountry parental child removal was incorporated into a Punjab and Haryana High Court judgment and referred to Law Commission of India also. He served on a government committee examining inter-parental child removal issues, contributing to a report submitted to Government of India in 2018. Mr. Anil Malhotra frequently lectures at prestigious institutions including National Judicial Academy and National Law Schools across India. Thank you, sir. Welcome, sir. Sir, please.
Good afternoon, everybody. Worthy respected Vice Chancellor, Professor and dear students. I am going to talk to you on a very important subject, which perhaps doesn't come much in your textbooks or codified laws, what we call statutory laws. And it has grown more of as a concept, as something which is an offshoot of what the courts have done. Now, just to give you a little background of what is this subject about. Since you're all third-year students, I'm sure you had the occasion to do a basic elementary course on family laws. So, as Hindus, which is our personal law for majority of Indians, in matters of marriage we are guided by the Hindu Marriage Act. In matters of succession we have the Hindu Succession Act. In matters of adoption we have the Hindu Adoption and Maintenance Act. But in matters of custody and guardianship, we are guided by what is called the Hindu Minority and Guardianship Act. There is an Act of 1956. It's very simply and in very plain terms says that the father and after him the mother, though both are equal as per the Supreme Court judgment, both are the natural guardian of the child, and the custody of a child less than 5 years of age shall ordinarily be with the mother. Now this is all what the Hindu Minority and Guardianship Act says. Section 3 of this Act also says that it is a subordinate legislation to a Guardian and Wards Act of 1890. So, in substance, in effect, if you have to go to court to seek a declaration on guardianship or custody, you have to invoke the Guardian and Wards Act of 1890 for a guardianship or custody order. Now, the 1890 Act, that is GWA, I will refer to the 1890 Act, is an outmoded colonial piece of legislation which looks at custody more as a single parent exclusive custody in exclusion to the rights of the other parents. Now, worldwide we have grown into a concept of joint custody, shared parenting, and taking decisions together in the best interest of the child jointly as parents. But we have not changed, we have neither amended the law, nor have we done anything bringing new concepts which we have to adapt to with the world. We are 1.4 billion, 35 million live abroad. So we are living in age-old concepts, regardless of the fact that large number of inter-country child removal matters are coming. Now coming back to where I left, so in sum and substance, whenever there is an interparental child custody dispute, be it within India or be it abroad, the removal of one parent, taking away the child, holding the child back, excluding the participation of the other parent, is not considered to be any wrong, any offense, or any violation of any law. So if a parent removes a child from a foreign country and brings the child to India, or if within India a child is taken away from one place and taken to another place, no offense, no wrong comes forth. Now let us see the contrast in the international perspective. Now, you will gradually learn that to live in a global world, we have to become a part of a network of laws which help people internationally. So we have the Hague Conference of Parental International Law based in the Netherlands, and the Hague, for short, comes out with conventions. Now these conventions are international instruments which have to be acceded to, which have to be signed by individual countries to become a part of those laws. So there is a convention on children's removal issue. It's called the Hague Convention on Civil Aspects of International Child Abduction 1980, or short, the 1980 Convention. 110 countries have signed it. India has not. So the result is that when a child is removed from a convention country means who has signed the convention and brought to India, we do not return the child. We don't apply the convention. But all the countries which have signed the convention have made a domestic law to incorporate the provisions of the convention, by virtue of which the domestic law creates a body or an authority which will entertain an application for child. Now we are a world apart, we are a country apart in terms of interparental child. We have not signed the convention. There have been various efforts made. I assisted the High Court for 12 years in a matter where a child was taken out of India, put the child to come and brought back. I made a report, the court submitted the judgment and my report to the government of India. And a committee was formed, headed by Honorable Mr. Justice Parental, who is now sitting judge of the Supreme Court. And we spent 2 years, there were 6 judges, 6 government officers. I was the only lawyer on the committee. And we explored on how to resolve the problem. We heard people who had been left behind, people who were abroad. And we made a bill in the 2-volume report and submitted it to the government, but the government has done nothing about it. So in this backdrop, in this scenario, I have been working on these matters of children's custody issues for the past 40 years. I handled my first matter in 1986. That was a case when a lady came looking for her son in Punjab. The father appeared in court and fled. The court issued an order that whenever he is found, he will be brought, the child will be brought back. Now, let us switch to the remedy part. So one remedy is which the parent who has brought the child to India or in-country retention of child by one parent, what does that parent do? That parent goes to the guardian judge, which is in the family court. If there is no family court, then the senior judge, civil division, and seeks individual custody, individual guardianship of the child in exclusion to the other parent. Now, it's a very outmoded way, it's a very archaic way that a natural parent has to perforce go to the guardian judge of the family court and become or seek to become a guardian of his or her natural born child. It sounds obsolete, but that's what the law is about. So this is the conventional remedy. The Hindu Minority and Guardianship Act makes both parents equal. So therefore, the court says if you want singular custody, you have to remove the guardian. Now the family court or the guardian judge can't fashion remedies. He can't design remedies. He's bound by the statute. So what happens to a parent who comes from a country abroad? Maybe he's an Indian, maybe he's a foreigner, maybe he's an Indian who has become a foreign national. He comes with a foreign court order and he wants the foreign court order to be implemented in India. There is no statutory provision in the Guardian and Wards Act or the Hindu Minority and Guardianship Act which can help. So what does that parent do? That parent invokes, I'm sure you've all been through the Constitution of India, the provisions in the High Court under Article 226 or under Article 32 in the Supreme Court for a writ of habeas corpus. You all know there are 6 different kinds of writs: go warrant, go certiorari, prohibition. Habeas corpus is one of them. Now, habeas corpus in 226 originated from the 1898 Criminal Procedure Code, whereby a person who was wrongfully removed or detained could be given back to the person from whom the person was detained or removed by the extraordinary jurisdiction of the High Court and Supreme Court. Why extraordinary jurisdiction? Why the Constitution? Because statutory law. Guardian what's that? Hindu minority tradition have no remedy. And child removal by a parent is not a wrong or offense. IPC doesn't consider child kidnapping by a parent to be a wrong. So this extraordinary remedy is invoked. The first reported cases of Bohar Begum in 1960, where the Supreme Court, interpreting American law, English law, said that the writ of habeas corpus is not to look to the illegal detention in child removal matters. It is addressed to the welfare of the child. And the High Court or Supreme Court in parents to play jurisdiction. Parents to play means as the guardian of the child, the court becomes the guardian. The court, in the best interest of the child, determines the welfare. Wrongful removal or retention is not an issue. Normally speaking, a habeas corpus, just for your understanding, is to secure the release of a person who is in wrongful confinement. For example, a person is detained in a jail or in a police station without a case, without a warrant, or somebody has illegally detained you and is not releasing you and nothing, you've been charged with nothing. But then when it comes to child custody matters, it's not wrongful removal or retention, it's welfare. Now this concept from 1960, Bohar Begum to Yashita Sahu, Lahari Sakharoli, Vasudha Sethi, this concept has undergone sea change. Now, the courts, because it is a constitutional provision, the interpretation much more served by the Supreme Court keeps evolving and it keeps changing. In 1984, the Supreme Court, Justice Y.V. Chandrachud in Surendra Kaur's case, laid down a fundamental principle saying that the welfare of the child will be determined by the jurisdiction which has the closest contact. Meaning thereby, if a child is removed from a foreign jurisdiction, the court of that country where the child goes to school, where the child lives, where the child is at home, ought to determine it. Now this principle has been followed consistently. But there have been other different principles. Justice Madan Lukur in Suryavardhanan came out with the theory of first strike. The court said, whichever jurisdiction takes cognizance of the matter first, India or abroad, will have the authority to decide. But in Nityanand Raghavan, a three-judge bench headed by Justice Deepak Mishra, said no, theory of first strike is not right. And the High Court and the Supreme Court will not implement a foreign court order to be asking. Foreign court order will be one consideration. Determination will take place in the best interest of the child. But jurisdiction of closest contact theory was consistent. Now, there have also been a flip-flop of decisions. In 1991, in Narasimha Rao's case, Supreme Court said, we will decide